already here where I'm sitting in Boston, Massachusetts. They've announced that next year's Boston Marathon will not be going forward, but we hope that is not the case with the FDI Moot, which will take place later at this time next year. So we hope the world will evolve at the same time. We're glad that you have all practiced your own form of resilience to adapt to using mechanisms like Zoom to continue with your studies and to compete in this competition. So welcome to everyone. Over the next almost week, we hope that you find that it's a rewarding experience to participate and go and show your skills to the other teams and to the arbitrators. So good luck to all of you. Now, Chris, turn it over to you. It's great to see you this morning.
Yeah, I usually feed off of the excitement of the students when we get together in person, and the travel thrill that you can see coming off of them. Many of them on their first professional business trip abroad, sort of. Unfortunately, we don't have that this year, but I think we've all had a long metaphorical journey to get to this virtual venue now. And for that, I want to say welcome, congratulations, and thank you for making it here. Just overnight, Manuela and I had a lot of messages of concern from friends, family, but also people in the FDI Moot community in connection with the terror attack in Vienna last night. And I could tell everyone now that we're fine, friends and family are fine, so that's good. On the other hand, there are at least 4 people dead from that, which may sound like a lot, but if you put it into perspective, what we're going through right now, we have more than 1.2 million people who have died from or with COVID in the last little more than half year, and the health and economic consequences of that will mean probably many millions more before this is over. However, even if those COVID-19 numbers seem big, they're actually quite small next to the impact that climate change may have on lives, incomes, businesses, and our general social fabric. And in the same way, over the past year, we've seen debates going on in all kinds of jurisdictions about how much to lock down for the virus, or how much we have to keep businesses and the economy open and running to keep the societies that are based on those businesses open. And I mean open societies in the broadest sense of the word. And we can also imagine different meanings of the word virus if we think of the challenges that are facing lots of countries. Now, election day in the United States with a lot of tension, and lots of countries all over the world. But that debate is also very similar to the debate that goes on with regard to the environment and climate change, and how we manage that. And I'm very grateful to the case committee for the 2020 problem, whom I'll just mention individually now. That's Tim Rauschning, Nikita Kondrashov, Dmitry Mednikov, and Lukas Denij, for focusing our attention on that issue of how you manage the challenge that climate change presents to us, and trying to keep economies, businesses, societies going, the way of life that we kind of know, going forward. So let's offer a round of applause to our case committee, and which we can't do virtually, just one of the many things that are not really convenient virtually. And with that, I think we could then go to a keynote address that we have, which will talk about the environmental regulation and investor state arbitration, and how that might change going forward. And with that,
before we do that, Chris, I just want to reflect on this year of 2020 and realize that, you know, one thing when I started in academics in 2004, 4 years before this competition started, it looked like the world was heading in a certain trajectory, a certain trend, one that involved a lot of multilateral cooperation, developing frameworks, international legal frameworks between countries. And what we've seen, at least particularly since 2016, is that risk has not gone away, and that there has been a real challenge to some of the systems that perhaps we took for granted, at least for a short period of time. This competition is placed in the field of international investment law, which is yet its own system of international legal frameworks. It's one that has been going through significant calls for reform, particularly since 2010. But it's important that it still exists, and that frameworks for resolving disputes in accordance with the law are as important now as they've ever been, particularly in a time where, as we see, as we experience firsthand, whether it's COVID-19 or any other number of factors, that risk has not gone away, that risk is as significant today as ever before. And I mean risks from all sorts of factors: technology risks, disease, governmental risk, risk associated with business, risks associated with so many factors. So here we are right now when we are developing this competition based on those types of risks, government responses to those risks, and their impacts on all sorts of members of society, including investors. And it's an important time to take that reflection and realize that these international legal frameworks are really important, so that people can get on with their lives, raise their families, and do what they need to do. So I find it an interesting time to be hosting the FDI Moot in 2020.
Thank you, Chris. And I think Juan Felipe is going to dig into that a little bit for us. Let me just briefly give you the full title of his address, and then introduce him very briefly. I think Juan Felipe is here and waiting in the starting blocks, ready to go. So the title of his address is "The Environment and International Investment Arbitration: Current Status and Proposals for the Reform of the Arbitration System in the Management of Environmental Disputes." Now, Juan Felipe Coy Gomez is a lawyer with Freshfields Bruckhaus Deringer in Madrid. Unlike most of the arbitrators that we have with us today, he's not an alumnus of the FDI Moot, but he is an alumnus of FDI Moot co-founder King's College London and their LLM program. And he's a graduate from Universidad Carlos III de Madrid, which has been a frequent participant in the FDI Moot over the years, successful participant. And for the purposes of the current thoughts that we're going to hear, Juan Felipe is a 2020 Nappert Prize winner. I think everyone's aware of this very prestigious prize that is sponsored by Sophie Nappert, one of our advisory board members, and McGill University, for an essay that he wrote on the environment and international investment arbitration. So with that, I would turn it over to Juan Felipe. I would ask everyone else to make sure that their microphones are muted. Juan Felipe, I believe at the end you might entertain a few questions or comments, but until then, please keep your microphones muted. Thank you. Felipe, the stage is yours.
Thank you very much, Christian, for the presentation, and thank you very much for this opportunity. I'm going to share my screen so you can see a presentation that I prepared for this case. Okay, so my paper is titled The Environment and International Investment Arbitration, Current Status and Proposals for Reform of the Arbitration System in the Management of Environmental Disputes. As everyone knows, climate change is one of the most significant challenges that the international community is currently facing As foreign investors face a changing regulatory environment, given the needs for states to respond to climate crisis, arbitration provides a forum in which investors can bring their claims against the hosting states. The goal of my paper is analyzing the regulatory framework for investment arbitration and its application by tribunals in order to determine whether the investment arbitration is currently an effective mechanism for the resolution of environmental disputes. The reference to environmental issues on investment agreements reflect the different positions that states have against the policies regarding environment. So we can classify this reference in 3 different groups. The first group of reference in environmental on investment treaties and free trade agreement are those clauses that make reference to recognizing environmental protection as an objective of the treaty. This type of language is often found as part of the treaty preambles. For example, we can find a reference of this example in the Canada Model BAT that includes a reference to sustainable development that constitutes a relevant guide to understand the objective behind the will of the contracting parties. Although these clauses do not usually imply a hierarchy of legal obligations of the treaty, they confirm that the protection of environment is one of the concerns of the contracting parties. The second group of reference are those dimensions that affirm the right of the contracting parties to regulate in environmental matters. These provisions may take the form of exclusions or exceptions. It is practically impossible to find a treaty that declares the will of the contracting parties to retain the regulatory power in environmental matters without being this power subject to several conditions. A paradigmatic example can be found in the 2016 Morocco-Nigeria BIT, but typically treaties like the US or the Canadian model includes a more general clause. These clauses allow states to enforce their environmental policies without breaching the treaty's obligations. The state invoking this provision must prove that the exception is applicable and that the acts or mission of the states meet the corresponding requirements. We can classify this reference in 2 different groups, exceptions or exclusions. The exception establishes that certain measures related to environmental issues may not constitute grounds for a claim. For example, in Annex B of the US Model BIT, it excludes environmental regulation from the scope of indirect expropriation. The 2008 Canada-Peru Free Trade Agreement contains a similar clause. However, in this case, the contracting parties place a greater emphasis on defining the concept of exceptional circumstances, restricting the possible scenarios in which arbitrators may consider that such exceptional circumstances exist. The other group are the reaffirmation of environmental obligations and prohibition of relaxation of protection standards. We can classify this reference into different subgroups. The first one are clauses which reaffirm the environmental commitments made by the states. An example can be found in the Dutch Model BAT. A second type can be found are these clauses prohibiting the reduction of environmental standards to attract or keep foreign investment. These clauses date back to 1992 with NAFTA. However, in NAFTA, they did not constitute a binding legal obligation for the parties. An example can be found in Article 8.10 of the Canada-South Korea Free Trade Agreement. The purpose of these clauses is to prevent states from starting or continuing a race to the bottom in order to attract or keep foreign investment. A third category are these clauses through which a state commits themselves to cooperate or create bodies for monitoring or facilitating the achievement of the objective of the agreement, such as the Environmental Affairs Council created under the Chile-US FIT. The OECD highlights the importance of regional agreements that include environmental commitments because they promote and improve the state's capacity to ensure compliance with environmental regulation. A comprehensive system of sanctions under the supervision of such bodies is essential to achieve the compliance with environmental regulations. Since most investment agreements do not make any reference to environmental issues, parties may pay attention to the case law existing in these cases. So we are going to analyze the different awards regarding environmental measures taken by states. Environmental disputes involve attention between competing obligations of the state. On one hand, they have to promote foreign investment. On the other hand, they have to protect citizens and territory from environmental damage. Environmental issues may be relevant to determine jurisdiction, liability, or damages. On the merits of the disputes, the state have defended themselves by alleging that the existence of a legitimate or rational basis for the adoption of the measures, by showing that its actions or omissions are intended to address environmental concerns, the state can demonstrate that its actions were neither arbitrary or discriminatory. Similarly, under the police powers doctrine, a state should not be liable for the consequence of a measure which, despite having an expropriatory effect on the investor or on the investment, they were taken in accordance with legally established procedures for a public purpose, such as the environmental protection, and in a non-discriminatory way. First, in analyzing possible breaches of the treaty, tribunals have focused on the effect of the measures on the investor to determine whether the measure was proportionate to the public purpose for which it was designed. In the case of TECMEC against Mexico, the tribunal considered that the local community opposition for environmental concerns did not create a situation of urgency, crisis, need, or social urgency that would make the investor's deprivation proportionate to the public purpose. Such conclusion lead in the opposite direction that the case of Marvin Fieldman against the US. In that case, the tribunal concluded that although it is difficult to draw a line between expropriation and the right to regulate, governments must be free to act in accordance with an interest through the protection of environment. Government regulation of this kind cannot be achieved if any adversely affected company can seek compensation. A similar position was held by the tribunal in South American Silvers against Bolivia. Therefore, Marvin Fieldman and South America Silver reflect a trend toward a conceptual change. Investment is no longer only affected by the legal regime, but is also affected by the environment in which it takes place. Therefore, there are several factors that may affect the investment, such as social factors, cultural factors, political, or even the environmental issues that will determine the rights and obligations of the investor and the state. Second, tribunals have analyzed the state motivation for adopting measures to determine whether it constitutes a conduct in favor of domestic investors or producers. Although it did not deal with environmental issues, it's important to pay attention to Saluca against the Czech Republic because it's a good example of police power doctrine. In this case, the tribunal considered that in determining whether or not an indirect expropriation exists, if there is a legitimate justification for the state to adopt such a measure, it cannot constitute an expropriation despite the effect on the investors. Therefore, the sole effect doctrine held in Santa Elena against Costa Rica has fallen into disuse. Tribunals over the past 10 years have included the legitimacy of the disputed measures as a key element in their analysis of allegation of expropriation, FIT, or any treaty clause with similar effect, as it was done by the tribunal in Methanex against the US. A third group of awards in which the tribunal's involvement with scientific evidence is relevant to the decision. For example, in Glamis Gold against the US, the tribunal considered that international tribunals were not required to grant any deference as domestic courts are required to do, but concluded that certain deference is already inherent in the standard of Article 1105 of NAFTA. Taking a slightly different position, the tribunal in Centura Corp against Canada declined to assess whether the chemical lindane posed a danger to human health of the environment. Instead, the tribunal looked at the administrative process for the approval of this measure In order to evaluate whether Canada has conducted a review of the scientific evidence as part of its legal obligations in Methanex against the US, this reflects the weight of this factor. The tribunal concluded the University of California report, in which California based its measures, represented a serious, objective, and scientific perspective of a complex problem. Focusing on scientific process and not on the scientific accuracy of the report, the tribunal emphasized the validity of the report as the result of an open and informed scientific debate. A fourth group of awards are those in which the tribunal considered that the environmental issues may affect the right of investors to receive a compensation. This was the interpretation of the tribunals in Perenco and Burlington against Ecuador, in which Ecuador filed counterclaims demanding compensation for the environmental catastrophe caused by the investors. Likewise, an investor may argue that the adoption at the international level of environmental regulation of the same subject could have limited or eliminated the profitability of the investment, as Canada did in the proceedings against Centura Corp. In conclusion, case law suggests that tribunals mostly consider environmental issues as factual instead of legal issues. The analysis of environmental issues influence how tribunals determine where the state had breached its obligations. Similarly, the tribunal analysis may also be relevant to questions of law, such as jurisdiction or the investor's right to receive a compensation. On the third chapter of my paper, there are several proposals in order to improve the investment arbitration system in order to adapt this system to the analysis of environmental disputes. There are challenges that investment arbitration must address in order to ensure appropriate balance between protection of foreign investors and environment. First, many investment agreements make no substantive reference to environmental issues. Those tribunals have no guidance on weighing the objective of such policy against other states' obligations. Second, treaties do not impose substantive obligations on the investors on many issues. There is an imbalance that can undermine the legitimacy of arbitrations in the eyes of public opinion. Third, tribunals have focused its analysis on the merits of the scientific evidence of environmental issues. Therefore, they face the overwhelming task of evaluating the reliability of these exhibits. There are a series of reforms to the state investment arbitration system that are proposed here. Review and reform of environmental treaties and their models. States might carry out a review of their agreements in order to ensure that measures for environmental protection are duly reflected in this agreement and on a similar level compared with the protection of economic growth. We have to have clear exception or exclusion clauses. Inclusion of properly drafted exceptions can provide greater protection against investor claims for environmental measures taken by the state. Such clauses would allow the state to retain regulatory power to respond with more flexibility to the changing circumstances of the climate crisis. Furthermore, these clauses would prevent the threat of arbitration proceedings that sometimes discourage the adoption of measures aimed at the protection of public interest, as happened in Canada when they try to regulate the marketing and advertising of tobacco. This is particularly important for states with low financial resources, as the case of Philip Morris against Uruguay show. Other possible reform is the inclusion of environmental counterclaims. Investment arbitration is sometimes perceived as a mechanism in which investors hold a preeminent position compared with the state. There are 5 scenarios in which tribunal may consider it has jurisdiction over the counterclaim filed by the state. A first possibility is that there is a provision on the treaty that may provide the possibility of the tribunal to hear a counterclaim filed by the state. A second option, even in the absence of express legal provision, tribunal may read the agreement in such a way that it considers that its function entrusted to the tribunal encompass knowledge of the counterclaims. There is a third possibility: the consent of the party to a certain set of rules which allow for counterclaims will imply the consent to the jurisdiction of the tribunal in this case. A fourth possibility is the agreement of the parties before or after the claim arises. And a final possibility is that the treaty may provide for the host states to have the capacity to initiate arbitral proceedings so that it is entitled to bring claims under the same conditions as the investor. Therefore, investment treaty may be amended to ensure that they include tribunal jurisdiction on counterclaims. If modification of the substantive obligations of the treaty is not possible, states may introduce in the preamble reference to international environmental standards such as the Paris Agreement. As far as existing investment treaties are concerned, a state could modify these treaties, but this would imply an analysis of the consequence on existing investment and the possibility for investors to circumvent this through the use of the most favored nation clause. Other possible modification of the current system is the inclusion of procedural system for the analysis of factual and legal issues. Generally, disputes related to environmental policies go hand by hand with technical issues. Since most tribunals have chosen to evaluate the scientific findings, this section proposes possible mechanisms for facilitating this task. First, the use of specific arbitration rules for environmental disputes. In 2001, the Permanent Court of Arbitration approved the optional rules for arbitration of disputes relating to the environment and/or natural resources. These rules are the most comprehensive set of procedural rules designed especially for environmental disputes. They contain special features for the appointment of qualified arbitrations given the nature of the dispute, the choice of experts, and assistance to the tribunal when it values and when it evaluates scientific or technical issues. Therefore, the work of international institutions in designing arbitration rules for environmental disputes is fundamental to promote arbitration as a forum for resolving these kind of disputes. Other option would be the intervention of non-disputing parties. Although initially the use of this mechanism was rare in investment arbitration, in recent years there has been an increase in third-party participation in the procedure, particularly through amicus curiae submissions. According to Amado, Kern, and Doe, the solution for the reticence of public opinion to investment arbitration is facilitating access to justice, understood as the possibility for host states and the citizens and the state of nationality of the investor to intervene in the proceedings. This is an opportunity to bring other technical and scientific views in the proceedings or to draw tribunal's attention to issues not addressed by the parties. For example, in Methanex, the amicus curiae brief highlighted environmental regulatory issues that were not otherwise addressed by the parties. In Gabriel Resources against Romania, the tribunal considered that amicus curiae submissions were admissible because they could provide the tribunal with particular knowledge of factual issues and also because there was a public interest in the proceedings because of the public opposition to the project. Participation of non-disputed parties increased cost of proceedings and imposed longer procedures for the parties. However, this can be minimized by specifying the number of submissions and their lengths, the quality required of the participants, and limiting them to specific issues, either legal or factual issues. Decisions taken by tribunals that value contributions made by non-disputing parties can benefit from greater acceptance by the public. Some sectors have questioned the legitimacy of ad hoc tribunals composed of foreign arbitrators to decide on regulatory democratic adopted measures by the state, as it happens in Eco Minerals against Colombia. Therefore, the conclusions of my paper are the following. There are concerns regarding the management of environmental issues in investment arbitration that lead to another issue that goes beyond environmental management, the need to balance the protection granted to investors and the capacity of the state to regulate in matters essential to its national interest. Investment arbitration requires special adaptation of its rules and procedures to respond optimally to disputes in which environmental issues are part of the analysis. In good part of the investment agreements, state parties do not establish any substantive obligations on the investors and the investment, and sometimes both exception and interstate commitments in this area are subject to conditions which make their applicability notoriously difficult. In the case of Canada, this is the country that I analyze in my paper because they have a lot of treaties and free trade agreements in which they make reference to environmental issues compared with other countries such as Spain, which only have 3 free agreements in which they make reference to these issues. It's a good example. It's a good example for other countries to follow in order to review their agreements. The existing in the network of Canada treaties, the existence of generic exclusions related to indirect expropriation, restriction of the right to sue the host state, regulatory reservations, or the prohibition of relaxation of environmental standards in most of its agreements make Canada a good example to follow for other states. Adapting the system is necessary in view of the foreseeable increase on disputes in environmental matters. This involves opening the system to allow the participation of the stake or other stakeholders, whose arguments may complement those of the disputing parties. There is a clear evidence of these openings that can be found in the interpretative work already carried out by tribunals. They move to the policy powers doctrine from the sole effect doctrine, the admission of counterclaims in Perella and Burlington case, the admissions of amicus curiae brief in Gabriel Resources are some examples of important steps already taken by arbitral tribunals on this file and show the potential of investment arbitration to become the most appropriate arena for environmental disputes. These proposals represent a restructuring of the rights and obligations of the participants in arbitration. Adaptation of the system is requires a commitment by states and international organizations with the objective of revising the regulatory framework to guarantee efficient protection for investors without compromising the interests of their own citizens. Thank you very much for your attention.
Thank you, Juan Felipe. I just couldn't find my unmute button. That's very interesting. And I can tell that you've done quite a bit of research on this. Do we have from the audience any questions? Just as a housekeeping matter, if you'd like to ask a question, feel free to turn on your video and then your mic and then ask. And if no one, Chris, do you have a question?
Sure. Yes, Juan, thank you very much for your presentation today. That was excellent. I'll give you 2 questions to get a bit of a discussion going. First, you said tribunals now are considering more focus on factual as compared to legal issues, I think in their analysis. And so I'd like to hear you expand on that thought and what sort of implications that has for how tribunals are deciding cases.
Yeah, in most of the cases, they only pay attention to environmental issues as a secondary element of the analysis. Most of the time, they pay attention to fair FET or expropriation, other clauses that they consider that is more important for the analysis. So environmental issues are kind of a secondary part of the analysis. So they only influence the factual analysis in order to determine whether the situation was the origin as the kind of technique that create an environment of the opposition to the investment. Therefore, it's not the key issue of the analysis as they should done. For example, in Perella, in their counterclaims, they focus more on the damage instead of the other issues, even though the main claim was regarding the expropriation of the oil basis. So they should make a conceptual shift from the current state of things. They should pay more attention to environmental issues, not only as a secondary element of the analysis, not only as a part of the analysis, a small part that could compensate or change the damages granted to the parties. They should be an independent part of the analysis that is actually varied by the tribunal, because there is a public opposition in several cases, especially in those regarding in natural resources, especially in South America, in Africa, and even here in Europe, as we see in the case of Gabriel Resources. So if tribunals don't pay properly attention to these issues, and they only value them as a key an additional element, is not going to be a proper adaptation of or analysis of the situation.
Thank you. I'll go ahead, and I still don't see anyone hands up. I'll ask a second question. This is sort of a big picture question. In the United States, when the Supreme Court issues a decision, it often has an impact on how laws are passed in the future. And we've witnessed in international investment law a real sea change, it seems to me. If you go back to the late 1980s into the 1990s, we saw a bunch of countries really engage in treaty practice to develop new bilateral investment treaties or free trade agreements with investment chapters. And that first generation of BITs, of treaties, did not include some of the types of exception clauses and language that you just referred to, with Canada being a prime example. Do you think that the cases that have been decided thus far and the litigation against the governments in investment arbitration has led to sort of a public education on the part of countries, and whether that has not just remained in the field of international investment law, which was a very rapidly growing field in the last, let's say, 30 years, but perhaps now influenced their practices in treaties in general and across the board? So it's a big picture question for you.
Yeah, it's so complicated because the first generation of treaties, they don't make any kind of reference to environmental issues. And right now, some countries are reviewing their models, like Norway, Canada, but there are other countries such as Spain or the US that are actually reviewing these clauses. So if they don't review these kind of clauses or the model BIT, it's quite hard to review already treaties that are already in force. But they may include any kind of references of the preamble, because actually if they don't review this reference, they're going to have a contradictory position, because they are at the same time being part of the Paris Agreement and other kind of regional or international agreements that may have contradictory obligations for the states, because at the same time they're assuming commitments to protect the environment, and at the same time they're assuming several commitments with investors that actually create a situation in which they are actually protecting the status quo of the situation. They are not changing anything if they are not guaranteeing that the investors are going to follow any kind of procedural steps or any kind of measures in order to make their investment as eco-friendly as possible. So if the countries did not reform this system, or just review, including reference in the preamble, or trying to reform their agreements, we're going to keep us in the same situation in which every time the public opinion show a more opposition to a system in which actually the state looks like a party that is not in the most favorable position against the investor, that actually have several rights against the state, that only is in the position of the defendant, but actually has not the possibility in many cases to file a counterclaim or try to find a solution to the damage that the investor has caused.
Thank you.
You're welcome.
I see we have a question from Arbitrator Gundras.
Thank you very much. Thank you for your presentation. I have a question. You mentioned you should further specify the environmental obligations in bilateral investment treaties and maybe refer to environmental treaties. So the problem I see is that these environmental obligations are often very vague, let's put it that way. You have an obligation to prevent, or you have to follow the precautionary principle, or in the Paris Agreement, for instance, you have to put up nationally determined contributions. So how should arbitral tribunals decide on whether an environmental measure meets these standards? I mean, it's very hard to do this. There is a lot of discretion for arbitral tribunals. And would you have any ideas how to further specify this in bilateral investment treaties? And this is especially also an issue when we come to investor obligations. Thank you.
Thank you very much for your question. Yeah, it's quite hard to address this question, especially because most of the treaties just include social responsibility clauses that makes even harder to achieve a decision for the tribunal, because they are just vague expressions about how they should do their best efforts in order to protect the environment. So I think that most countries should make actually a review and include really clear examples, such as the Canada model, that even make a reference. And they state that for the protection measures taken for the protection for the promotion of sustainable development, and actually they specify what are the exceptional circumstances, because for example the US model just make reference to exceptional circumstances, but what are these exceptional circumstances? So I think that the treaties should include, at least try to include, a more detailed list of cases, such as protecting certain species, or protecting the air against the air pollution, or protecting the water resources of the country. If they try at least to make a short list through annexes or any kind of element without modifying the core treaty, they may help the tribunals to take a decision without being contradictory in one case or another, because if they have just vague expressions about how to protect the environment, it's going to be hard for the tribunals to take a properly taken decision.
Other questions?
In the chat, Team Bastide started to put a question in. I don't know if they've quite reached the end of it. Team Bastide, if you'd like, you could put your camera on and ask the question directly to Juan Felipe.
Okay, sorry, I'm being very shy here today from one of the other continents, but no, my question just is simply this. It relates to the legitimate expectations. Do the changing regulatory regimes that are coming into different countries and different situations, and the modifications that are happening over time, are they going to have some effect on what investors' legitimate expectations might be when they're making their investment decisions?
Thank you very much for your question. Yeah, obviously the legitimate expectation of the investors are going to be affected by the steps taken by the states. However, it should be a whole analysis of the situation. If normally these measures are not taken in a short period, they are taking more like long period decisions. They are not immediate decisions taken just to apply in this right moment. So they are most of the time decisions that imply the reduction of pollution in 10 years, or the elimination of certain materials in 10 years, the reduction of use of certain resources in a longer period. So actually the expectation of the investors are going to be affected by the tribunal should take into account that most of the time the analysis should not include a short-term analysis, but a longer-term analysis that value it's obvious that the expectation of the investors are going to be affected, but in most of the cases, states should retain a certain power to regulate the national interest, such in the case of environmental damages, because if we just limit the regulatory power of the states in any way that any company and investor affected adversely have the right to claim against the state, is going to be actually we say in Spanish, a petrification of the law because there is no way in case the state can modify their legal framework in order to achieve the state policies. So as long as there is no clause in the investment treaty or the investment agreement with that investor that guarantee the investor the legal framework that they have when they make the investment, I should that investors and any other kind of business that make an investment, even in the national framework, such as a national investor, they have to assume that there is a certain grade of possibility that the legal framework is going to change through the time.
Thank you.
Thank you.
Okay.
Juan, let me go ahead and ask you. Well, I see actually we have a hand up from Team Mensa. Please go ahead.
Yeah, hello. Thank you for your presentation. I have the following question. Regarding all modern problems with environment, can we assume that the protection of environment is now a part of jus cogens, and the tribunals can apply it as a principle and protect it even without any references in the BAT? Thank you.
Thank you for your question. I don't think that environmental protection can be considered as part of the jus cogens, because actually there's different levels of protection. So for certain countries, the protection of the environment is not one of the main important problems. So for example, developing countries consider that environmental protection is part of the goals of the state, but economic growth is one of the main goals of the public policy. Therefore, there is no harmonization, there is no standard that is for all the levels. So for example, in the case of Europe, normally European countries assume that the environmental protection is one of the goals of the European Union, and countries such as Canada consider this as well. But for example, in the case of the US currently, as we have seen in the case of Trump policies, they do not put a great emphasis on the protection of the environment. And it's the same, for example, for India and for China. They are shifting right now to a more greater environmental protection, but it is not a common level for all the states. So it would be hard for a tribunal to consider that, even though there is no regulation on the treaty or in the investment agreement with the party, that they have the right to consider that environmental protection is one of the goals of the treaty.
But maybe it's just it's necessary to make a first step to start considering it like this.
Yeah, it should be. Actually, I mean, if countries achieve a more homogeneous agreement, it could be. For example, if the Paris Agreement would be an enforced agreement for all the countries or a greater acceptance, but right now the Paris Agreement is enforced but is not accepted by several countries. Therefore, actually the acceptance of this kind of agreement as a common level for all the states would be hard.
Thank you.
Thank you.
Let me ask a follow-up question and perhaps give a comment. In the United States, there's an author named Saul Griffiths, who has won the prestigious MacArthur Award, the MacArthur Genius Award. And he's written a book about how to decarbonize the United States and create 25 million jobs. And so in his approach, he, and this might lead to questions about whether investors can ever be compensated, he suggests that rather than penalizing the fossil fuels industry, we should actually pay those companies for the assets they have in the ground, meaning their oil and gas, and bring them on board, use their engineers and their business executives to help bring forward essentially a rewiring of the country to alternative uses of energy. But what's interesting about his analysis is that he thinks that the way to do this is actually to recognize and compensate fossil fuel companies as part of the movement towards addressing climate change. And so it's kind of an interesting counterpoint to this idea that we leave those companies completely out and, when they were existing under a previous regime that where many governments were subsidizing them, right? And subsidizing their activities because, as we know, one way or another, we're all going to continue to need to use energy in this world. And those industries are always essential in one way or another. And now perhaps they're going to be replaced by new forms of energy production. Any comments on that, Juan?
Well, it's a really interesting focus. For example, here in Spain, the state is subsidizing this kind of traditional investment in order to they invest a higher proportion of the income in renewable energies, in green car, in this kind of technology that can improve and reduce the pollution. So I think that it would be a great opportunity for states to achieve an agreement because there is it's a great proportion of workers or investors or companies that are still in that sector, so they should not left behind because actually for the economy it would be great. So if countries achieve an agreement on a transition that imply the use of this qualified people, these companies that have experience in managing resources, it would be great to achieve how they transition to a new, more green economy.
Chris, do you see any more raised hands, any more questions? Otherwise, we might move on to our next segment of the program.
I think in the chat.
Oh yes, Team Gray. Team Gray, go ahead and turn your video on and pose your question.
Can you see me?
Yes.
Can you see me? Can you hear me? Okay,
Yes.
I would like to ask if nationalization of these companies you mentioned before, all the conventional energy investments that were made in Spain, for example, could Spain nationalize some of them, because all of them, I understand it's difficult, instead of paying too much for subsidies? Couldn't be a solution?
Thank you very much for your question. I think that nationalization is not a possible solution for this case, because actually, if a state, for any reason, just for environmental purpose or for competition with other countries or free trade wars or trade wars, they opt for nationalization, actually they are going to send a really weird message to international investors, because they're going to think that there is a higher risk of investing in that country. For example, that was the case of Argentina during the crisis or even before, because investors didn't feel the possibility of investing in that country because the investment, the legal framework was really unstable. So actually, if they see that there is a risk of nationalization, such as Bolivia during the last decade, they're going to find other places, other countries in which they are going to invest.
Let me just add a comment to that in the context of tumbling oil prices now, and also seeing, for example, in the context of COVID-19, airlines seeking bailouts from states, where states then take an interest in the company. Maybe that's not so unrealistic. Maybe states could see that, taking a national interest in a company as part of a bailout, so to speak, a climate change bailout, might not be so strange, perhaps. Maybe, I don't know. Maybe that just came to my mind right now. I probably should have kept it to myself. If there are any more questions, otherwise I think we probably should move on now.
Video, maybe.
Video there. Video. Thank you very much, Juan Felipe.
Thank you
Please
very much.
hang around with us some more. Maybe some people will have some questions or ideas for you in the socializing time that we have now available. Seeing Sandra reminded me that we're on to our next stage, which is Q&A for team captains and any arbitrators who are interested in participating in it, just about sort of logistical aspects of the competition and things like that. In order to do that, Manuela is going to open up a lot of breakout rooms. These breakout rooms will include a whole bunch of lounges, which are places that you can socialize in smaller groups, including a lounge where Sandra will be in case anyone wants to find out about the University of Miami's LLM in international dispute resolution and the opportunities there. I think including they have some scholarship opportunities that are fairly generous. And she's got the sunny background there, which will entice a few people as well, I'm sure. So I would ask Manuela if she can to open up the breakout rooms. When she does that, there'll be, I think, a total of about 30 breakout rooms. So if you want, you can gather in small groups. Please take advantage of the opportunity. She'll open the breakout rooms with the option to choose your own breakout room. That means everyone in this meeting now can go to the breakout room that they want to. They can say, hey, let's go to Lounge 1, Lounge 2, Lounge 3. Let's go to Lounge University of Miami. The team captains should go to the lounge called Team Q&A, and any arbitrators who are interested in logistical questions about the competition should also go there. Juan Felipe, maybe some people will grab you and say, let's go to the lounge and talk more about reform of environmental aspects of investor-state arbitration. Perfect. And what else did I want to do? I also wanted to introduce our tribunal secretaries, our chief tribunal secretaries. I think Arunima is on the line still. I'd ask her to very briefly turn on her video.
Hello, everyone.
She will be joined over the next 4 or 5 days by 3 other chief tribunal secretaries, Shretha, Sayamantak. I don't know if he's on the call.
I think both of them are here. I think Shretha definitely is.
Am I visible?
Yes. Good to see you. And Sayamantak, are you there? They're going to be running the Zoom meetings where the hearings will be taking place. Some of you already know Arunima and Shretha because they did that in the Africa regional and the South Asia regional with great success and helped us refine all of our processes and things. So you'll see lots of them over the next few days. Good. With that, Manuela, can you?
Yes. I'm going there.
Roll out the magic carpet.
Well, let's see. You did it all. I'm just clicking the buttons. I'm starting them now with Auswahl gestatten.
So you'll get, and then if you look down at the bottom of your dashboard, you'll see a thing that says breakout, and you'll have lots and lots of options.
They're all open now.
They're all open now. The arbitrator zone is the room that we'll be using later on in about 45 minutes for a panel discussion with the arbitrators about this year's case. That room is not open to team members. Okay, that will be in about 40 minutes from now. That will start. So team members, please don't go into arbitrator zone, but otherwise go any place you'd like to. I should point out also that the Chris Gibson will from time to time be in the Suffolk Lounge in case people want to hear about Suffolk generally, and we may have someone from King's College London and Pepperdine as well from time to time in those lounges. I'm going to go off to Team Q&A now. Chris, are you going to join me there?
Yes, I'll be right there. I'll be right there.
Okay, thanks.
Chris, can I ask you one question?
Yeah.
Is it possible to go to the breakout rooms if I'm using a mobile phone, or do I need to log in with the desktop?
It's definitely easier with the desktop. It might be possible for you to ask Manuela to send you to a breakout room, but you probably won't be able to go on your own initiative from the mobile.
All right, then I'll leave and I'll probably join again with the laptop.
Okay, sounds good.
Perfect, thank you.
I'm gonna stop the live feed because I don't think I can do that in a breakout room anyway for your Q&A.
Right, yes, you can stop the live feed. Thank you. And you might want to go to arbitrator zone and remind Irene Rembeth, who's with Team Zhu that
Yeah.
she shouldn't be there, but should be in the Team Q&A one.
Yeah.